Danielle Tamarova on behalf of the state.
Sana M. Rashid from Rashid and Associates, appearing on behalf of Ms. Nguyen, who's present for trial in court, Your Honor.
Okay, thank you. And Mr. Rashid, you're ready for your cross-examination? Okay.
Emerald, how are you today? Rashid. So I obviously have several questions for you, but the first starts with where you initially saw Ms. Nguyen's vehicle.
Near San Pedro and Corona, which is the road right next to Stoneface.
You essentially saw her pulling out of Stoneface Tavern, right?
Right next to it, yes.
And the area that you pulled her over is south of Paseo del Norte, correct?
Yes, sir.
So you see her come out of Stoneface Tavern, and that's when you claim that you saw the driving behavior?
Yes, sir.
When you made initial contact with Ms. Nguyen, you explained or you told her the reason for the stop, right?
Yes.
And then she began to explain something to you, and then you interrupted her and just talked over her and kept going, right?
I'm not sure.
You had a passenger, right?
Yes.
And that was a male?
I believe so.
And he started talking to you when you attempted to talk to Ms. Nguyen, right?
I don't recall. I don't recall.
So you went around another car to pull her over, correct?
Yeah, I would go into that left turn lane to pull her over, because I was going to pull her over before the stop sign.
So the second you engaged emergency equipment, she responded immediately, correct?
Yes.
Now, when you made initial contact with her, you asked her for her documents, right?
Yes.
And you asked for three things?
Driver's license, registration, insurance.
Okay. And she was able to provide you the three things, including one, I think, an expired insurance on her phone or something like
Yes.
that, right?
Yes.
So she didn't have to be reminded, she didn't have to be prompted. You
No.
asked for the three things, and she provided the three things. She was even able to pull up the insurance on her phone, show it to you, even though.
Yes, correct.
Now, when you made initial contact and then you go back to your vehicle, what do you go back to your vehicle for?
To run the documentation. I didn't have time to run the plate, so I ran that before back there as well. And retrieve and just make sure everything corresponds with each other, everything's correct.
Then that's when you want to have contact with her again, correct? After you're in your vehicle, and then you go to re-engage with her.
Yes.
You don't go back up to her vehicle and have her get out, do you?
No.
You actually get on your speaker, or I don't know.
I just yelled.
You
Yeah.
yelled?
Yeah, I didn't use the speaker on that one.
Okay.
No.
And so you yelled for her to exit her block to you.
Yes.
Why do you do that?
There was a second person in the vehicle. I just like to minimize the number of approaches making to the vehicle. as it's an uncleared area for me. I don't always do it. I don't do it as much anymore as I was. It was something I was trying out, back then as much as I'm not doing it as much now.
Fair to say that that isn't included anywhere in your NHTSA training, correct?
No, that's not part of NHTSA. That's an officer safety training.
So that's just something that you do or did for a while or occasionally do. I mean, I understand sometimes, let's say, there's 5 people in the car, or
Yeah.
there are 5 tough-looking people in the car,
Right.
or, but you're dealing with a relatively small female, right?
Yes.
And you know that when you make initial contact.
Yeah, back then I was doing it to pretty much every stop, keeping it consistent. Like I said, I've since changed. It's just, it was new training we had gotten back then. So,
Say new training, I don't have any other Bernalillo County Sheriff's deputies on the DWI unit sitting this way.
they had talked about it in the McGrain training.
In what?
The McGrain training?
Oh, okay.
Yeah. The concept was, had he done that kind of call out, that he wouldn't have gotten shot in the face. That was kind of the thing behind it.
Now, you testified regarding my client admitting alcohol, right?
Yes.
And you testified that she had 3 beverages at Bubba's and then 2 more at Stoneface.
Yeah, and I'll have to correct that here.
Okay, so the accurate reflection is that she said she had 3 total beverages.
Correct.
1 would have been at Bubba's, and then 2 at
Stoneface. Correct.
And she was extremely specific about when she finished consuming alcohol, right?
Yes.
At 7:22.
Correct.
And now we're at 2 in the morning.
Yes.
Did she have any issues with the exit of her vehicle?
Not that I noticed.
And that's something that you're trained to look for, right?
Correct.
You're also trained to look for and keep track of that idea if everybody provides the documents that you request. And you request 3 of them on purpose, right?
Yes.
You don't ask for one and have them produce it, and ask for the other and have them produce it, and ask for the third. You ask for all 3 at once because it's based on your training, because that's also a memory test, right?
Yes.
So you testified about your training and said that you went through the initial academy training in 2010, and at some point you became a standardized field sobriety test instructor, right?
Yes.
And when did you become an instructor?
January of 2013.
So you were asked a question about how many DWI investigations,
Yes.
and you said over 1,000. And you were asked, do you arrest everybody you investigate? And you answered, you don't arrest most people you investigate, right?
Yes.
Have you ever done an investigation where you suspected alcohol impairment, made an arrest, had the person submit to a breath test, and this person was not at a .08 or higher?
Yes.
How often does that happen?
Not very often, no.
But it happens.
Yes.
And it has happened.
It has happened, yes.
And you've had cases where you've done your job, you've made your arrest, you've done interviews, you've shown up for court, you've gone to trial, and you've lost, right?
Yes.
So would your testimony be that you never make a mistake in a DWI investigation?
No.
Would your testimony be that you are always right about your impressions in a DWI investigation?
No.
So in this case, you were asked about alternative tests.
Yes.
You didn't do any alternative tests in this case, did you?
No.
Now, when you made initial contact with Ms. Nguyen, she did not have slurred speech, did she?
No.
Now, when you had her conduct the horizontal gaze nystagmus test, you give the instructions of follow the stimulus with your eyes and your eyes only, don't move, right?
Yes.
And very often when you do that test, people have to be reminded to, follow the stimulus or don't move your head, things like that, correct?
Yes.
And you're trained to look for that as well.
Yes.
And Ms. Nguyen followed your instructions without any issues on that test.
Yes.
Now, on the walk and turn, there are different ways that officers can explain and demonstrate the test, correct?
Yes, as long as it meets the standard of touching each of those instruction points per NHTSAS. Yes. Yes.
The manual doesn't specifically include those parenthetical.
No, now the manual it says to do the as long as there's a verbal and physical instruction and it meets those criteria that we just discussed, then it would be okay.
Prior to, then explain it, right?
Yes.
And then there's the simultaneous explanation.
Yes.
And you didn't do the immediate explanation and demonstration. You did it where you explained the entire test while she was in the position, right?
Yes.
And that creates a pretty decent time period that a person is going to have to stay in that instructional position if you do it that way, correct?
Yes.
And despite doing it that way, Ms. Nguyen did not step out of the instructional position once you got her in it, did she?
She did not.
And then the next thing you're trained to look for is if she starts too soon, right?
Yes.
And she didn't do that.
Correct.
Now, on the first 9 steps, well, let me just ask you in general when it comes to the walk and turn test. You know that you have a video running, right?
Yes.
And you know that the bulk of the issues on the walk and turn, well, I won't say the bulk, but several of the issues on the walk and turn test have to do with what your feet are doing when you end a step, whether they are heel to toe, whether they're offline, all of that kind of stuff, right?
Yes.
So the feet are important.
Yes.
And you, as being a trained deputy and then being an instructor, should know how important it is for your video evidence to track and cover as much as possible, right? And that's the goal, right?
The video was employed by the sheriff. For us back then, it was just a dash cam. It wasn't body cams or anything like that. So in all fairness, the video was there, but that wasn't my primary tool. It was there for us to use, and we used it. I didn't try and look and see what angles were appropriate when doing all of it. It's just not something I did.
So you generally know if a person is too close to your vehicle to capture everything or too far from your vehicle, right?
Not really. I mean, as far as the video goes, that was relatively new to us back then because we were the only people in the department with dash cam. I think it was us and K9. And so the hood of the car, what I'd find out after eventually is that it was always obstructing. I'd have to be way far back for it to get the full plane, and it just wasn't really reasonable for me to even be that far back from the traffic stop. I mean, it was like 30, 40 feet in order to get the whole plane.
Maybe a video equipment issue?
Most likely, yeah. But now it's solved because we have body cam,
Right.
so now we
But
can
in
do it
this
now.
case, we can't see her feet while
Correct.
she's walking, right?
You're right, yes.
Okay. And so, as I understand it, you told her to take 18 total steps, correct?
9 each direction.
Okay. 18 total steps, right?
9 plus 9 is 18, yeah, but not in that
So
fashion.
she took the first 9 steps, didn't do the turn, and then took an additional 9 steps.
Correct.
So, as I understand your testimony, the issues that she had were that you said she missed heel to toe on steps 3 and 7
Yes,
by a half inch or greater.
yes.
Nothing egregious. No, we're not talking about 2 inches, 3 inches, 4 inches.
I don't ever specify. It's either it meets the threshold or it doesn't.
Okay. And then you said on the same step, number 3, it was offline?
To the left.
So those, during the walking phase of the test, those were the only things that you observed, correct?
Correct.
Did you treat the second 9 steps with the same focus on the actual clues that you're trained to look for?
No, I did not.
Why?
Because the test was already greatly changed at that point because she never completed a turn and all she was doing was walking now. So we were already past the point where that test was being monitored in the same way. It was already the incorrect number of steps, and I wasn't monitoring heel to toe or stepping offline anymore.
Clues on the walk and turn test are theoretically all weighted equally, right?
Yes, there's the 8 clues, and they're weighted equally.
Okay, so if a person steps out of the instructional phase or they miss heel to toe, same kind of analysis, right? It's 1 clue.
Yes.
Okay. So the turn is also 1 clue, right?
Correct.
And so why would you fail to analyze the second 9 steps just because she didn't do the turn?
Because I believe it's a significant deviation from the test.
So despite the fact that you told her to take 9, and then you told her to take 9, which she did, you didn't think that the second 9 steps were important to evaluate?
I don't believe it was because it was a significant deviation because there was no change in direction and there was no following the same line.
Out of 8 clues that you claimed were stepping offline, 1, heel to toe on 3 and 7, and stopping, no turn, right? Is there anywhere in the NHTSA manual that says that you are to ignore 9 steps if a person doesn't do the turn?
No, because it doesn't address if the person doesn't do the test in its entirety correctly. It's only addressing how the parameters of the test are and how to interpret the test given the completion of those parameters.
For your contention that you ignore the second 9 steps?
I'd have to go through it to verify what the instructions are for not significantly deviating from the instruction on the test.
At it, or is it something that you have an idea where that might be, or?
I have no idea. It'd take me a while.
Okay. You have been teaching EWI to at least 2 cadet classes every year for the last several years too, right?
Yes, sir.
And so your familiarity should be pretty clear with the both student and instructor manual.
Yes.
But you can't point to anywhere that tells you to ignore the second 9 steps.
I don't think there's anywhere specifically given that scenario. It's not laid out in the manual where the individual keeps walking continuously. It's not specified in the manual that.
So do you have any memory of how well she performed on that second series of 9 steps?
No.
So it's possible that she touched heel to toe on everyone?
It's possible.
Didn't step off line?
It's possible.
Didn't stop while she was walking, because we see that, right?
It's possible.
Right, and then you move on to the one-leg stand, right?
Yes.
And you are doing that as a timed 30-second test, correct?
Yes, sir.
And the things that you were trained to look for on that test is whether a person sways, whether they put their foot down, whether they use their arms for balance, and whether they hop, right?
Yes.
And the materials say that, like, you know, a minor foot tremor or something isn't a sway, right?
No.
That's the question better. Isn't it correct that they say minor tremors of the foot aren't considered a sway, right?
Correct.
Okay. So as I was looking at the one-leg stand on this video, well, let me just back up and say your testimony was that she swayed 3 times, right?
Yes.
At 5, 10, and 15?
The route there, yeah.
And what do you consider a sway?
So what I'm referencing is, and she has a nice bright car, so to the background of her contrast where her body was, you can see the movement, any noticeable movement in a side-to-side, or if I would have notated different, it could be forward-back, but I was notating the side-to-side.
At NHTSA doesn't otherwise even define a sway.
No, it does not.
So of all specific clues that NHTSA includes in the field sobriety test, the sway is one of the only ones that they don't define, right?
Yes.
And none of the times that you're saying that she swayed were significant enough to cause her to put her foot down, use her arms for balance, or hop.
Correct.
To her explaining that she had consumed the 3 alcoholic beverages, she also told you that she consumed food.
Yes.
Explain both having a burger and some wings and having half of her burger in the vehicle if you wanted to see it, right?
Yes.
Now, got to talk about this question of yours. Okay, on a scale of 1 to 10, 10 being the most hammered you've ever been, how do you word that question?
So on a scale of 0 to 10, 0 being completely sober, not intoxicated, or not intoxicated at all in any way, 10 being intoxicated to the point of passing out, getting sick, or not being able to care for yourself. Where would you rate yourself right now?
Your answer was a 2 or a 1, right?
Yes.
Some people fall into that trap pretty good for you, right?
Many people answer that question, yes.
Okay, they'll give you a 5 or a 6 or a 7 kind of number.
Sometimes. Mostly it's in the lower numbers.
All right, so that question has never appeared anywhere in a NHTSA student or instructor manual for DWI, has it?
No.
That question isn't something that's part of your standardized field sobriety testing protocol, correct?
Correct.
You are the one that's evaluating whether somebody's able to drive safely or not, right?
Correct.
You rely on them all the time. If they say, no, I'm a 0, do you just say, okay, have a nice night?
It goes towards the totality of circumstances.
Okay, so this question isn't one that has come from your training, isn't one that's come from the instructor classes or the student classes or even A-RIDE, which you've been to also, right?
Yes.
So you've been through standardized sobriety test training, you've been through A-RIDE, you've been through instructor training, and that question doesn't exist in any of your training materials, does it?
Nope.
So I noticed during the one-leg stand that you were looking at your, what I'm assuming is some type of smartwatch, Apple Watch or some type of watch like that, right?
So,
And you are touching it at certain points. I'm assuming at the points that you think that she was swaying.
oh no, that's to keep the screen on so I can monitor the seconds.
So you aren't tapping it for any other reason?
No, I tap it because,
Keep it lit up?
yeah, to keep it lit up. That's it.
Okay.
Because after a few seconds, then it turns off.
All right. And as I see you now, you're looking down at your watch,
Mm-hmm.
and then you look back up at me, right?
Mm-hmm.
And you did the same thing when you were tapping it with her on the one-leg stand, correct?
Yes.
So you're looking down at your watch during part of that test and not always watching Ms. Nguyen for her performance on that test.
Yes, I have to monitor the time, so I'm checking it.
Now, on the one-leg stand, you ask her to count by thousands, correct?
Yes.
1001, 1002, 1003, and continue until I tell you to stop, essentially, right?
Yes.
And I believe that she stopped at the count of 20, correct?
Yes.
That was at the 30 seconds.
Yes.
And during that counting period, she counted correctly from 1 to 20 when you stopped her, right?
Yes.
She included the thousands in between every one.
Yes.
She didn't skip any numbers,
No.
miss any numbers,
No.
repeat any numbers,
No.
hesitate or pause with any numbers.
No.
Now, it is standard BCSO procedure for you to call for a backup unit if you are actually going
Yes.
and called for a backup unit that night.
Yes.
And as best I could tell from the video, it appeared to be Deputy Mark Goulet, who's one of your...
Yes.
Part of your training is to make sure that you don't distract the driver while they're doing the sobriety tests, right?
Yes.
And he would presumably know that as both a trained officer and also a trained instructor.
Yes,
But during your administration of the field sobriety test, he walks right by where you guys are doing the testing and goes to just look at her car, right?
checking to see if there's occupants in it.
Okay, and then he comes back during that same time, and then he stops, and then he stays there and watches.
Yes,
So he's moving around while you're doing the field sobriety test with Ms. Nguyen, correct?
yes,
Approaching her vehicle, which would be something that maybe somebody might be interested in, why is the cop going to my car?
suppose it could be possible, yes.
Did you ask Ms. Nguyen about any interaction between her and the passenger leading up to the traffic stop?
No,
Asked the whole 1 to 10 question. She indicated also that she had stopped and drank water because she knew she was going to drive, right?
yes,
Can I have just a second, Your Honor?
Sure.
Said that she used a left signal and then made a right movement. The left signal was on very briefly, right? Like it illuminated, and then it turned off as she started to move to the right, correct?
right, which would make sense, because once you move the wheel to the right, the turn signal's not gonna stay left.
To a certain degree, you can do things gradually and...
No, I'm saying the vehicle mechanically, you know what I mean? You turn to the left, start turn signal on turn right, it's gonna click off the signal.
I get it.
Yeah.
I'm saying that there is some,
Yes, there's,
like, you could turn kind of wide and it's not going to turn off, but if
Correct.
you turn sharply, then it will,
correct.
right? Witness, thank you, Your Honor.
State.
Deputy, I have a few questions. First, something I wanted to clarify. What time was the initial stop?
About just after midnight, 0:15.
And, could you tell us again, what are the standard field sobriety tests that you usually use?
the HGN, or the horizontal gaze nystagmus test, the walk and turn test, and the one-leg stand test.
When do alternative tests get administered?
When there's a belief that the individual may be impaired to an ability that could affect the interpretation of those tests.
Why were they not administered in this case?
Because there was no medical conditions or impairments that I believed would have an effect that would have led me to believe I couldn't properly interpret the test based on our physical condition.
Were the explanations and demonstrations that you provided, Ms. Nguyen, accurate per the NHTSA standards?
Yes.
Were they the explanations you always use when you explain these tests?
They were the ones that I consistently use. Obviously, it can never be 100% the same, but very consistent with each other.
And in your belief, did Ms. Nguyen understand all of your instructions?
Yes, that's why I asked, do you understand, and do you fully understand prior to having them start the test?
Now, specifically to the walk and turn test, is the instructional position part of the test?
Yes.
And is the turn also part of the test?
Yes.
In the instructions, is there a direction in which the second part of the steps are supposed to be taken? The second set, sorry.
Yeah, after the turn.
So let me try to rephrase. Would the first set of 9 steps and the second set of 9 steps be taken in opposite directions?
Correct.
So was the defendant able to complete that test per your instructions?
No.
And would it be fair to characterize it as the defendant never took a second set of 9 steps?
Yes. I'm going to object to the form of that question as to, in terms of whether it would be fair or not. I think that's for the court to evaluate and not for the officer's opinion to testify in the manner on the question.
Okay, so the objection is sustained. Go ahead and rephrase that question.
Officer, or I apologize, Deputy, would you, in your experience, your training, and your knowledge of the NHTSA test, what would you say the defendant, I apologize, what set of steps would you say the defendant completed?
First 9 steps.
And what happened after those first 9 steps?
The defendant stopped the test and did not complete it correctly, not completing the turn and the second set of 9 steps.
What would have been the correct course of action to complete the test?
For Vivian to complete the turn in some manner, and then to go ahead and complete the second set of 9 steps going the opposite direction.
Now, to the one-leg stand. What are the clues that you look for on the one-leg stand?
There's 4 clues. There's putting your foot down, swaying, hopping, and using your arms for balance.
What are the clues that you observed?
Swaying.
When you asked the defendant about her perception of how intoxicated she was, what was her response?
2 or a 1.
And what did that lead you to believe?
All that question leads me to believe is that they're feeling some effect, some impairment above sobriety, completely sober.
And does the state have any other witnesses to call?
No, Your Honor.
Okay, can we excuse Deputy Hamro?
Your Honor.
Just for the moment?
Yes.
Okay, while I hear argument, and then we'll see where we're at. If you can hang out in the hallway, thank you, Deputy. Okay, defense filed its motion on probable cause. The burden shifts to the state to prove probable cause. So I'll hear from the state first, then I'll hear from defense.
Your Honor, I would just like to start with the standard for probable cause. As stated in State v. Sanchez, a police officer has probable cause when the facts and circumstances within the officer's knowledge or about which the officer has reasonably trustworthy information are sufficient to warrant an officer of reasonable caution to believe that an offense is being committed or has been committed. In this case, the reasonable officer was Deputy Hamrill, but the standard does not look at just his observations. It's any reasonable officer in his situation. And as he testified, any reasonable officer would have followed the same standards, would have given the same instructions, and would have come to the same, would have seen the same results, whether it was the
officer would have done in this case, or what any other officer would have observed in this case, or what any other officer would have conducted in this case. The only thing that matters is what he did with Ms. Nguyen on the night in question, not what other officers.
State your response.
Yes, Your Honor, my response is that he was a reasonable officer using the reasonable standards at that time, and that's the standard for probable cause of a reasonable officer.
Okay, the court will not take into account that argument, so essentially the objection sustained.
Yes.
I didn't hear any testimony about what other officers do.
On the night in question, Deputy Hammerl testified that he followed his usual instructions. He followed his training, his experience, and he has been trained to train other officers. He has done what he does in his, as he testified, over 1,000 DWI investigations, and that he testified that he observed clues on both the walk-and-turn test and the one-leg stand test. He told us that the defendant told him, and we saw in the video, that she consumed alcohol. She admitted to him that. She told him how many drinks and when. She also mentioned, you know, about food and water, but she also told him when he asked her that she felt she was above a zero. Your Honor, although the state may be proceeding on a per se, we can also proceed on impaired to the slightest. And if by the officer's belief and by the totality of the circumstances that he saw, a reasonable officer would have also come to the same conclusion, that Ms. Nguyen was at least impaired to the slightest, and that she was not safe to drive, she was not safe to be on the road, either herself or the vehicles around her, or the passenger in her vehicle.
Judge, I have to kind of bounce around a little bit, but I'm going to start with the argument that the state makes that he is following his training and his experience. Not here, Judge. What we have here is an officer that is sort of ignoring part of his training, not following it. We have the circumstances where he indicates that the whole having somebody, like, barking at them to get out of their vehicle and walk back to his vehicle to interact with him there as an officer safety issue. We're talking about Ms. Nguyen. You can see her. There was nothing threatening about her, no allegations of threat towards Deputy Hammerl, no allegations of her having furtive movements, of her doing anything that would justify that method of exit. Obviously, when the officer comes up and interacts with you at the location and sees you in your vehicle, he gets an idea of what's going on. He sees how many people are in there. He sees if there are any apparent weapons. He sees if there are any apparent disrespectful issues. All of that kind of stuff, none of which existed here. So barking at her to come back to his vehicle, yelling at her to come back, isn't consistent with his training. Then we have a circumstance when it comes to the alcohol consumption. He testifies that she had at least five beverages, but then his report indicates that she admitted a total of 3 over a very specific time period, 6 o'clock to 7:22, and we're talking about 2 in the morning. So the circumstances are such that she explained her alcohol consumption, her food consumption, all of that to him, and he gets her out of the vehicle to do the field. I think we have a situation where he's not following his training with reference to the walk and turn as well. Because, Judge, there are 18 steps that are required. 9, turn, 9, okay? So she does 9, she doesn't do the turn, and she does 9 more. For Deputy Hammerl to say that he is not considering her second 9 steps because they weren't in the right direction does not make sense and is not consistent with his training. Nothing in the manual says you are to ignore the second 9 steps if they don't turn. The turn is 1 clue out of 8. 1 clue. That's it. Just like heel to toe, just like offline, just like stopping, just like all of that. It's 1 clue. So for him to say, I took into account her first 9 steps and ignored everything else because she didn't do the turn, is not reasonable. Her second 9 steps, if she was to touch heel to toe on every one, would that be important to the court? If she didn't step offline on any of them, would that be important to the court? If she stopped in the middle of the 9 steps, would that be important to the court? If she didn't count the steps correctly, would that be important to the court? If she used her arms away from her side, would that be important to the court? So half of that test, he entirely ignores, doesn't evaluate, doesn't remember, and can't testify about. And then based on his positioning of my client in the video, you can't see it either. So he has essentially deprived the court of valuable information that goes to the reasonableness of his arrest decision. So in this circumstance, let's just kind of go through the things that she did fine, like immediate recognition of the emergency equipment and pulls over to the right correctly and stops. Immediately produces all 3 documents, although the insurance card on her phone was expired. But she was even able to pull up the insurance card on her phone and show it to him, which I've seen so many videos where people are just looking and hitting and looking and hitting and looking and hitting and aren't able to keep the brain together long enough to pull it up. We don't have that here. She pulls it up immediately. She provides her driver's license. She provides her insurance and provides the registration. Then she is asked to exit the vehicle. She exits the vehicle with no problem. She's asked to walk to a certain place. She walks to that place with no problem. She's asked to stand on his light. She does that with no problem. You can see everything from like knees up, Judge, on the walk and turn test, on the HGN test, and on the one-leg stand test. With reference to the walk and turn, you can see that her arms stay at her side. She's walking in a straight line. She doesn't have any significant deviation. She doesn't have any deviation that the court can glean from looking at the video. The officer testifies that she missed heel to toe 1 time by a ½ inch or greater on that first set of 9, and then I think he said she stepped offline. But you can see that there are no deviations, there are no arms coming up, she's walking in a straight line, she's counting her steps correctly, she doesn't have slurred speech as she counts those steps. So she does the first 9 steps, and then she does the second 9 steps, and the officer ignores it. Doesn't have any information for you as to what she did on half of a standardized field sobriety test. As we've indicated, and as the officer testified, every officer is supposed to use the same test, the same clues, evaluate it, explain it, demonstrate it the same way. Yet here, despite it being 1 clue about the turn, ignores the second 9. It's not reasonable, and it's not fair, and it's not appropriate for him to decide what evidence he should consider and shouldn't consider, and what evidence the court should consider and not consider. He's making a decision for you. He's making a decision for her. He's making a decision that isn't appropriate under the circumstances. It's not reasonable under the circumstances to ignore the second 9 steps. Not reasonable, not fair, not appropriate, not under his training. Nothing says to ignore the second series of 9 steps. Nothing in the instructor manual, nothing in the student manual, and he acknowledged that fact on the stand. Then we get to the one-leg stand test, Judge. and she's asked to raise her foot, to keep it up for 30 seconds, to look at her foot, to count by thousands, and he's timing her for 30 seconds. Counts to 20. No problems with her count. No problems with the thousands in between. No problems with her arms coming away from her side. No problems with her foot going down. No problems hopping on the base foot. And I submit to the court to claim that she swayed at 5 seconds, 10 seconds, and 15 seconds, when you can see her in the video and there's no visible sway. None, Judge. He acts like it's some significant front, back, or side-to-side sway that he's counting, and the court can see in the video that she maintains her position, maintains her foot in the air, 6 inches off the ground, pointing her toe, counting exactly as instructed. Judge, there is no sway on that test. I think that that is a chicken stuffed clue, okay? And by that I mean to claim that in a 30-second time period, somebody swayed at 3 different seconds. You don't see it, Judge. It's not there, and it's not appropriate for the state to really claim that clue, counting against Ms. Nguyen. Then, at that point, she's placed under arrest based on the officer's testimony on a totality of the circumstances. He doesn't know anything about what was going on in the car before the traffic stop. Didn't ask, didn't check, didn't care, didn't matter. So under the circumstances, we would submit to the court that the state has not proven to a satisfactory level that Deputy Hamrill had probable cause to arrest Ms. Nguyen on July 10th of 2020. Almost 2 years ago, Judge. I think under the circumstances, having the video helped them testify. At the same time, I don't think that they've established what they need to establish to justify my client's arrest that night by Deputy Hamrill, and we would ask the court to suppress the balance of the evidence based on fruit of the poisonous tree under the New Mexico Constitution, Article 2, Section 10. Thank you.
Give me 1 second, Ms. Tamarova, then I'll hear from you. Okay, state.
Been introduced, and I believe as Deputy Hamrill testified, there was a passenger in the vehicle. He also testified that at that time, it was standard procedure to ask somebody who they had pulled over in this traffic stop to walk out of the vehicle, not to go back. So that was standard procedure. He was following his training. The deputy also corrected his testimony about the number of drinks. He acknowledged that originally he was incorrect. It was just the 3 drinks as the defendant told him. Additionally, there's something I'd like to point out that defense has mentioned a couple of times that it was 2 a.m. However, that's inaccurate. She was stopped at midnight, around midnight at 12:15 a.m. And although she mentioned that she stopped drinking, she was drinking from 6 p.m. to 7:22, unfortunately, that's not the statute. The issue is whether or not at the time of driving she was impaired to the slightest, not whether or not she was drinking 4 hours from driving. That's just not the question. As for the walk and turn, I would just like to point out again the clues that the deputy testified to and what he was considering when he decided that she failed that test. He mentioned that she missed the turn, but he also noticed that she stepped off of the line, she did not connect her heel to her toe, she stopped when she was not instructed to do so after the 9th step. She didn't do the turn as properly required, as was explained to her. Even though she was instructed not to stop, she was instructed to do 9 steps, turn, and go back 9 steps. And as the deputy mentioned, her second, or, the continuing of the 9 steps was not the second set of steps, as they were not in the right direction. They were supposed to go back to where she came from. And on the video, unfortunately, you can't see her feet, but that's what the deputy was looking at, and that is what his report is based on, and that is what his testimony was based on. And so, by the deputy's standard, as a reasonable officer, and by his totality of the circumstances, everything he saw, everything he heard from her, he decided that she failed the test and that he could arrest her. And, Your Honor, I would ask that you find that the state did prove its burden, that there is probable cause for arrest. Thank you.
I'd like to take the video back and take a look at the video again, so if you can please get that for me. And I'm looking at my notes. Okay, I'll go and step off, take a look at everything. I'll come back as soon as I can. Thank you.
We step out of the courtroom, Your Honor.
Good morning, how are you? Or it's almost afternoon, about probably, well, 12:01 now.
I saw you driving the other day. I didn't realize it was you, though, until I had passed, and then I thought, oh, it's
I hope I was driving okay.
You were.
Okay, we're back on the record in T4DW 2020-1024, State of New Mexico versus Vivian Nguyen.
Daniela Tamarova on behalf of the state.
And Osama M. Rashid from Rashid and Associates, appearing on behalf of Ms. Nguyen, who's present, Your Honor.
Thank you, and thank you for your patience, parties. I went back, I looked at the video, all the relevant portions of the video, looked back at my notes, regarding the testimony as well as arguments that both sides made. And this is what I'm coming up with. Deputy Hammerl did, first of all, see driving that he felt was, I guess, suspect. Saw Ms. Nguyen following the vehicle in front of her too closely, using her signals, kind of, I guess, not consistently with her movements. Saw her also rolling to a stop at the stop sign. And so those were the reasons why he stated that he stopped her. Deputy Hammerl also observed bloodshot, watery eyes and odor of alcohol. Ms. Nguyen had also made admissions to drinking alcohol and gave detailed information regarding that. So I noted those. I also noted that Ms. Nguyen stopped and pulled over appropriately and within a reasonable amount of time was able to give documents, didn't have any slurred speech either on the video, and Deputy Hammerl didn't note that either. I was considering the officer's observations, as well as what he observed in the driving and the field sobriety tests. So with the heel to toe test, I wanted to go back and look at the video to see the instructions to make sure that Deputy Hammerl did give proper instructions, specifically regarding the turn, the number of steps, and whether Ms. Nguyen understood those instructions. Deputy Hammerl did ask her whether she understood. She said that she did, and he did explain the turn. That was one of my questions, and I did watch the video the first time, but I didn't focus on the turn, at the demonstration of the turn at the time I was watching the video, so I wanted to go back and look at that. And so I did see him demonstrate the 3 steps plus the turn, asked Ms. Nguyen if she understood, and she said she understood. On the video, I see Ms. Nguyen wobbly during the first 9 steps. Of course, we can't see her feet, but I'm relying on Deputy Hammerl's observations, and it also seemed like he was speaking them out loud into his recording so that for his note-taking purposes or reporting later on, that's what it seemed like to me. So when Deputy Hammerl saw 4 clues on the first 9 steps of the walk and turn, as he testified, and we noted on the video, he testified that Ms. Nguyen missed heel to toe on steps 3 and 7, didn't properly do the turn, stopped at the 9th step, and stepped offline on step 3. So those were 4 clues that he observed. I am not necessarily taking into consideration whether the second 9 steps. I know Mr. Rashid, you argued that he should have noted how she did on the second 9 steps. But what I'm focusing on, and he could have seen the same clues, I don't know, but what I'm focusing on is he saw the clues that he did see on the first set of 9 steps. And those were the clues that he saw: the missing heel to toe, 3 and 7, the not making the turn, stopping at 9, and stepping offline on the 3rd step. And so that's what I'm looking at. I know that your argument was that he should be taking note of all of the investigation, even if she didn't properly do the turn and come back the opposite direction. But regardless, the court takes note of the clues that he did see in the first 9. On the one-leg stand, I see a very minimal sway. I see Miss Wynn count appropriately, doesn't miss anything, does fine. I think the sway is negligible. I think it's a very, very minor sway. So all of that taken into consideration, the totality of the circumstances, the driving, the admissions to drinking alcohol, the performance on the walk and turn, not giving much weight to the one-leg stand because there wasn't very much there to see. My understanding is that if there are 2 or more clues on any of the tests, can indicate impairment at or above a .08, and that's what the officer relies on. I believe that there was probable cause to arrest Ms. Wynn. She seemed to be able to communicate well, cooperate, those kinds of things, but the driving is suspect. Her admissions to drinking alcohol and her performance on the heel to toe, even though, you know, there doesn't seem to be greatly impaired compared to what other tests I've seen, there still shows impairment, according to Officer Deputy Hammerl and his experience and training. So I'm relying on that. So for those reasons, I am finding that there was sufficient probable cause to arrest for DWI. And did you want to make any argument for the record, Mr. Rashid?
I kind of do, honestly, because...
Let's make sure you're close to the microphone so that for the record we make sure, and you can stay seated if you'd like.
All right. So, Judge, I guess the concerns I have is that when the court says I'm not really putting much emphasis on the one-leg stand when that's a test that she does very well, is concerning to the defense, and the idea that we are ignoring...
Well, when I said I wasn't giving much weight, I meant that I wasn't noting very much impairment on the one-leg stand. Not that I wasn't giving it weight, just that I didn't note very much impairment. Just to correct that, but go ahead. I'm sorry.
With the basis for driving, there wasn't evidence of the driving submitted to the court in the probable cause motion other than the deputy's testimony. So under the circumstances, I understand the court's ruling, but you asked me if I had any objections, and I do have concerns about how the court evaluated the evidence in the case, but you are the judge, so that's how it goes.
And I appreciate that. I just wanted to give you the opportunity to put anything on the record that you wanted to. And so at this point, with the court having found probable cause for arrest, do you want to proceed with the remainder of the trial?
Can I have a second to talk to my client, just
Sure.
explain where we are and all that, and then we can pick up from there?
Sure.
Okay, thank you.
Sure, go right ahead. I'm going to stay right here. I'm just going to look at some emails while I'm sitting here.